Hello friends, welcome to ProTalent, and we are bringing one of the very important support for you from your CLAT exam point of view, which is called Key Learnings from Recent Supreme Court Judgments. I'm sure you know that the latest Supreme Court judgments will have direct consequences in your entrance exam. कैसे आएंगे? There may be questions which are pertaining to some factual part of this particular judgments. ठीक है, या तो वो करंट अफेयर में पूछे जाएंगे या लीगल एप्टीट्यूड के अंदर पूछे जा सकते हैं, या there are certain issues which you need to understand कि क्या क्या sections अलग अलग लॉ के या क्या कौन से आर्टिकल कॉन्स्टिट्यूशन के लग सकते हैं. This is what you need to learn, and therefore this particular session will help you to understand in great detail. Okay, here in this key learning from recent Supreme Court judgment, session number 1, I am going to discuss two part. One is, you can say, section 377 and section 497 of IPC. So here the focus is IPC, and these are the two important judgments, and we are discussing only these two important judgments in this particular video. Let me start. So let me talk about this brief history of section 377. Okay, now what is this 377? It says whoever voluntarily has carnal intercourse against the order of nature with any man, woman or animal is punishable. Okay, so ये एक तरीके का प्रिंसिपल क्लैट में पूछा जाता है. जैसे क्लैट 2017 में बिल्कुल ये पूछा गया था, सेम डिटो प्रिंसिपल था, एक्सेप्ट अ पर्टिकुलर वर्ड एनिमल वाज नॉट देयर, एंड फैक्ट में ये एनिमल के साथ कोई ऐसा कार्नल इंटरकोर्स हो रहा था, देयरफॉर इट वाज नॉट अ क्राइम, क्योंकि हमें क्लैट में प्रिंसिपल जो बोलता है वही अप्लाई करना है. वी आर नॉट रिक्वायर्ड टू वरी एट ऑल ऑन एनी अदर थिंग. आई होप दिस इज वेरी क्लियर टू यू. ओके, चलिए, सो नाउ वी आर अंडरस्टैंडिंग what was this 377 of IPC was all about. So it was introduced in 1864 by Britishers. It was modeled on Buggery Act of England, wherein sodomy, okay, that is a kind of, you can say, sexual intercourse which is considered to be a kind of bestial, that means a kind of, you can say, animal like. ठीक है, तो उसके रिलेटेड एक लॉ बनाया गया था, उसी के ऊपर से इंडिया में इंट्रोड्यूस किया गया था 1864. Then it was continued in Delhi High Court in July 2, 2009. They said section 377 of IPC was in violation of fundamental rights like 14, 15 and 21 of our constitution, and therefore they said that it is decriminalized, that is any homosexuality is decriminalized. But in December 2013, Supreme Court set aside this Delhi High Court order, saying that it is not unconstitutional. It said that this 377, it is not unconstitutional, and therefore this gay rights activist also filed curative petition. That means saying that whatever the kind of judgment coming from Supreme Court, we want it to be corrected. That's called curative. In January 2018, Supreme Court referred the curative petition on homosexuality to the 5-judge bench, and they felt that it involves a very important issues concerning the constitution. Okay, so therefore they referred this entire issue to the 5-court judge bench. Okay, now what happened? How did we reach to this particular stage? To reach to this particular stage, सबसे पहली मूवमेंट जो चालू हुई थी, that was AIDS भेदभाव विरोध आंदोलन in 1991. 1991 में एक एनजीओ था. Remember, I am discussing the brief history on the case as well, because a law aspirant has to be very clear about the historical aspect of many cases. Okay, and therefore in the latest changes which are coming in the CLAT examination, not in terms of the, you can say, exam pattern, but in terms of the type of questions, they try and check this capability. So this NGO, this is AIDS Bhedbhav Virod Andolan. They have worked in support of women in red light area. They also distributed condoms to male inmates because of concern over male sexual health. They also published one very important write-up, and it is called Less Than Gay. Okay, it was published by this ABVA, and it narrated in detail about how the problems of these people and in what manner we have to sort out. So this is what the very important document came. Now, this NGO wanted to distribute condoms to male inmate in the jail, and at that time, the superintendent of that Tihar jail was Kiran Bedi, and she refused to allow health workers to distribute condoms to male inmate, and she said this is not, you can say, legal. And subsequently, NGO AIDS Bhedbhav Virod Andolan filed a petition for the repeal of Section 377. It failed to take follow-up on it, and thereby it was dismissed in 2001. The case got dismissed, but then came another case called number 2, called Nas Foundation versus Government of Delhi. In December 2001, very famous Nas Foundation, this is Nas Foundation, filed a PIL in Delhi High Court. Now what is PIL? Public interest litigation. 3 years later, it was dismissed on the ground that petitioner had no locus standi. मतलब उन्होंने ये बोला that petitioner का कोई locus standi नहीं है, that why are they, you can say, raising this issue. ये उनके ऊपर सवाल हो गया. अब पब्लिक इंटरेस्ट लिटिगेशन में डायरेक्टली आप अफेक्टेड नहीं हो, फिर भी आप किसी और के बिहाफ में केस कर सकते हो. So this is what the PIL was, and a review petition was filed at Supreme Court, and Supreme Court decided that Nas Foundation had standing to file PIL. उनके पास PIL फाइल करने का स्टैंडिंग है, and this case has to be sent back to the Delhi High Court to reconsider it on the merit. In 2009, on July 2, historic judgment was delivered by the Division Bench of Delhi High Court, comprising of Chief Justice A.P. Shah and Justice S. Muralidhar, who declared Section 377 of IPC is to be in violation of Article number 14, 15 and 21. Okay, I'm sure you know Article 14, that is right to equality and equality before law, and then 21 is right to life and personal liberty. Then came the chronology number 3 called Suresh Kumar Kaushal case. Now, Suresh Kumar Kaushal was astrologer in Delhi, and he filed a case against Delhi High Court's judgment. Okay, and thereby Supreme Court said that look what Delhi High Court decided was it is not, we can say, appropriate in Indian context, and they looked at a lot of other, you can say, cases, that is they looked at a lot of foreign cases, and thereby we remove the Delhi High Court judgment and reinstate Section 377. The court left it to the Parliament to consider the desirability and propriety of this particular issue. Supreme Court decided to revisit this judgment after several curative petitions filed in 2017, and came the last case, which was called Navtej Singh Johar case. In June 2006, Navtej Singh Johar, okay, and the other 4 members filed a writ petition in Supreme Court challenging 377. It was a 5-judge bench case. In this connection, 3-judge bench of Chief Justice Deepak Mishra noted that a section of people or individual who exercise their choice should never remain in a state of fear. And the bench ruled that the decision in Suresh Kumar Kaushal case needed to be reconsidered, and therefore it has to be referred to a larger bench, which is a 5-judge bench. Okay, so this 5-judge bench rightly observed that the social morality changes from age to age, and that the morality that public perceives and the constitution may not conceive what is natural to one or may not be natural to other. So therefore constitution may not have a full capability to understand कि क्या चीजें moral बन गई. कुछ जमाने में शायद ये homosexuality may be termed as immoral, but in today's time people have freedom to take their own choice, and उस choice के मुताबिक it is their right, वो उनका अधिकार है. ये जो 5 जज बेंच की सामने रेफर किया गया, उसके लिए एक और महत्वपूर्ण बीच में केस आया. क्या केस था? बहुत महत्वपूर्ण केस बना. दैट वाज अबाउट, यू कैन से, प्राइवेसी इशू, राइट टू प्राइवेसी जजमेंट. दैट केम इन अगस्त 2017. और ये उसका राइट टू प्राइवेसी ये पूरे केस के लिए बैकबोन बन गया. ये आधार के साथ कनेक्टेड केस आया था. राइट टू प्राइवेसी, 9 जजेस बैठे थे और यूनानिमस डिसीजन आया दैट राइट टू प्राइवेसी इज एन इंट्रिंसिक पार्ट ऑफ लाइफ एंड लिबर्टी अंडर आर्टिकल नंबर 21 ऑफ इंडियन कॉन्स्टिट्यूशन. भारत के संविधान के आर्टिकल नंबर 21 के मुताबिक ये हमारे राइट टू प्राइवेसी is an intrinsic part of life and liberty. It declared privacy as an intrinsic to life and liberty, an inherent right protected by Part 3 of the Constitution. Life and personal liberty are not creation of Constitution. वो Constitution से बनाए नहीं गए. These rights are recognized by the Constitution. It is inherent to an individual. हर एक बंदे के साथ जिनकी यहाँ पे पैदा हुई उसी के साथ उसके साथ ये बन के आता. दे आर इंसेपरेबल पार्ट ऑफ ह्यूमन एलिमेंट. दैट मीन्स एनी ऑर्डिनरी मैन कैन डायरेक्टली अप्रोच सुप्रीम कोर्ट एंड हाई कोर्ट फॉर वायलेशन ऑफ दिस फंडामेंटल राइट अंडर द कॉन्स्टिट्यूशन. एंड रिमेंबर, इट इज नॉट जस्ट द सिटीजन but anyone, because article number 21 is given to anyone. So this became a very base for this particular 377. ठीक है. सो अब ये 377 का जजमेंट और राइट टू प्राइवेसी किस तरीके से कनेक्ट हुआ. ठीक है. नाउ हाउ दिस 377 is connected with right to privacy. The judgment on right to privacy was observed that in a Kaushal judgment has not appreciated the fundamental right to privacy. उन्होंने बोल दिया सुरेश कौशल के जजमेंट केस के अंदर ये राइट टू प्राइवेसी को बहुत ध्यान नहीं दिया गया. In the right to privacy judgment, it was stated that LGBT rights are inherent in the right to life and they constitute essence of liberty and freedom. Therefore, sexual orientation is essential component of identity. एक बंदे की आइडेंटिटी का ये बहुत महत्वपूर्ण पार्ट है. And therefore, equal protection demands that protection of identity of every person without any discrimination. And therefore, privacy includes at its core preservation of personal intimacies, sanctity of family life, marriage, procreation, home, sexual orientation. ये सब चीजें उसके साथ कनेक्टेड हो गई. And therefore, जो दिल्ली हाई कोर्ट ने बोला था that ये सेक्शन आर्टिकल नंबर 21, 14 और 15 को वायलेट करता है, वो बिल्कुल सही है. if we go by psychological disorder related issue, अगर हम इसको लीगल की जगह पर अगर हम बिल्कुल मेडिकल केस पे लेकर चले, ठीक है, तो साइकियाट्रिक सोसाइटी है दैट इज कॉल्ड इंडियन साइकियाट्रिक सोसाइटी. वो भी ये बोलती है दैट इट इज टाइम टू स्टॉप लुकिंग एट homosexuality as a mental illness. There is no scientific basis that sexual orientation can be altered by any ट्रीटमेंट. अगर वो कोई ट्रीटमेंट के द्वारा ऑल्टर किया जाता तो बिल्कुल ये एक मेंटल इलनेस का कहा जाता. एनी सच अटेम्प्ट मे लीड टू लो सेल्फ एस्टीम एंड स्टिग्मेटाइजेशन. ऐसा उन्होंने अपना जजमेंट दिया. ओके, चलिए, ग्रेट. सो दिस इज व्हाट दिस आईपीएस टॉक्स अबाउट. एंड इफ यू टॉक अबाउट वर्ल्ड ओवर, व्हाट इज द सिनेरियो? द वर्ल्ड ओवर, भाई ये अलग अलग देश है जो आपके सामने दिख रहा है. ठीक है, वहां पे गे मैरिजेस आर अलाउड. सो इन ब्रिटिश जिन्होंने ये लॉ बनाया था, they themselves got rid of this law by 1960s. ठीक है, and many countries have already got rid of such law, and India also got rid of this section 377. अब ये जो 377 हमने निकाल दिया, उसके बाद क्या होगा भाई? उसके बाद कंसिक्वेंट राइट्स आएंगे, क्या क्या राइट आएंगे भाई. होमोसेक्सुअलिटी इज नो मोर एन ऑफेंस, देन इट मे लीड टू डिमांड टू लीगलाइज सेम सेक्स मैरिज, इनहेरिटेंस ऑफ सर्वाइवरशिप अमॉन्ग द गे पार्टनर्स. तो ये इश्यूज चालू हो जाएंगे और इसके ऊपर भी लॉ बनाने पड़ेंगे. ठीक है, एक्सटेंशन ऑफ कॉन्स्टिट्यूशनल राइट्स टू सिटीजन्स इररिस्पेक्टिव ऑफ देयर जेंडर और सेक्सुअल ओरिएंटेशन. ठीक है, ये सब चीजें इसके साथ लगेगी. So this is about section 377 of IPC. I hope this background is very clear. So now let me go and talk about 497, and it talks about adultery. 497 adultery. यहाँ पे भी I will explain to you all the background. मैं आपको पुराना background भी समझाऊंगा. ठीक है, और आप इस पूरी कहानी को अच्छे से समझ पाएंगे. So adultery. अब adultery के साथ प्रॉब्लम ये था कि adultery जो सेक्शन 497 आईपीसी में है वो जेंडर बायस्ड था. ठीक है, कैसा था? जेंडर बायस्ड, एंड दैट इज वेयर द प्रॉब्लम इज. ध्यान रहे, ऐसा नहीं है दैट एडल्टरी को लीगल कर दिया मतलब ये प्रमाणित हो गया जाके करो, ऐसा नहीं बोला. ठीक है, ये समझना बहुत जरूरी है. तो पहले समझते हैं एडल्टरी किसको बोलते हैं और आईपीसी में आईपीसी के द्वारा किसको बोलते हैं. हूएवर हैज सेक्सुअल इंटरकोर्स with a person who is and whom he knows or has a reason to believe to be the wife of another man without the consent or connivance of that man. ध्यान से देखिएगा, without the consent and connivance of that man मतलब उस आदमी को पता नहीं है. अगर उस आदमी का कंसेंट है तो ये पूरी कहानी बिगड़ गई. ठीक है, अगर उस आदमी का कंसेंट नहीं है, ठीक है, such sexual intercourse not amounting the offense of rape is guilty of offense of adultery and shall be punished with imprisonment of either description for a term which may extend up to 5 years or with a fine or with both. In such case, wife shall not be punishable as an abettor. Abettor मतलब जो क्राइम करने के लिए उत्साहित करता है. ठीक है, वो कभी भी वाइफ अबेटर नहीं हो. मतलब क्या हुआ? Let's say there is a family 1 and let's say this is family 2. There is husband, there is wife, there is husband, there is wife. ठीक है, मानो this husband has, you can say, a relationship with this wife और इस पर्सन को नहीं पता है. ठीक है, तो इस बंदे ने क्राइम किया, एडल्टरी माना जाएगा. ओके, हाँ, इन्होंने कोई क्राइम नहीं किया है, दैट इज वुमन, दैट इज वाइफ हैज नॉट कमिटेड एनी क्राइम, ऐसा माना जाएगा. इन केस हस्बैंड नोज इट, इन केस हस्बैंड नोज इट, नो क्राइम. ठीक है, नो क्राइम. एंड इन केस इफ दिस हस्बैंड हैज अ रिलेशनशिप विथ अ सिंगल वुमन, दैट मीन्स शी इज नॉट मैरिड, इफ दिस इज अ सिंगल वुमन, नो एडल्टरी. ठीक है, तो अगर हम बात करें, इसको इंटरप्रेट करें तो इसके 3 इंटरप्रिटेशन होते हैं. पहला, दैट मैरिड वुमन इज नॉट गोइंग टू बी रिगार्डेड एज एन एबेटर. एबेटर का मतलब है जो क्राइम करने के लिए उत्साहित करता है वैसा, विच मीन्स दैट वुमेन विल नॉट बी हेल्ड लायबल फॉर द एक्ट ऑफ एडल्टरी. इट इज ओनली मैन who is involved. Number 2, the law does not apply in the case where an unmarried woman has intercourse with a married woman. तो ये दूसरा पॉइंट हो गया. And finally, the act is not regarded to be an offense or can be cured of its criminality if husband of the married woman gives consent. अगर husband ने consent दे दिया तो भैया कोई गलती नहीं है. So that means it was a gender bias. It is always man is a wrongdoer and woman will always be victim. ठीक है, and women is a property or chattel of the husband. So this is how the scenario was. So the apex court in a 3 separate occasion in 1954, 85 and 88 upheld the constitutionality of this section 497. Okay, ये उन्होंने बोला. चलिए, ग्रेट. सो ये इंटरप्रिटेशन था. वापस इंटरप्रिटेशन एक और एंगल से देखते हैं. ठीक है, इट ट्रीट्स वुमेन एज वर्स देन अ ल्यूनेटिक, मतलब उसको मैड माना जाता है. इट एज्यूम्स दैट अ वुमन टू बी इनकेपेबल ऑफ हैविंग अ साउंड माइंड एंड exempts her from punishment even though she herself may lure a man. अगर वो खुद किसी मैन को ल्यूर करती है तो नहीं गिना जाएगा. ठीक है, सो देयरफॉर व्हाई इज दैट अ मैरिड वुमन is given such a blank check to indulge in a sexual relationship and therefore there is a problem. Okay, तो ये जेंडर बायस था, इसके लिए ये केस आया. अब क्या क्या केसेस हुए थे? टोटल 3 केसेस. सबसे पहला केस देख लेते हैं. द फर्स्ट सुप्रीम कोर्ट जजमेंट. ओके, इट केम अप इन 1951. तो तुरंत चैलेंज आ गया, देश आजाद हुआ और ये चैलेंज आ गया. सो इन दिस केस यूसुफ अजीज वर्सेस स्टेट ऑफ बॉम्बे, petitioner contended that adultery law violated fundamental right of equality under article 14 and 15. ठीक है. The dominant argument in the court hearing was that 497 governing adultery law discriminated against men by not making women equally culpable in adulterous relationship. It was also argued that adultery law gave a license to women to commit a particular crime. 3 years later, in 1954, Supreme Court ruled that Section 497 was valid. It held that Section 497 did not give a license to women to commit adultery. It said that it is primarily to protect women. Okay. Then came second Supreme Court judgment. It was named as Sumanth Vishnu versus Union of India case in 1985. In fact, जो 2018 का केस आया उसमें ये एफिडेविट की तरीके से डाला गया था. इन सौमित्र विष्णु केस, सुप्रीम कोर्ट हेल्ड दैट women need not be included as an aggrieved party in the name of making law even-handed. कि भाई लॉ को इक्वल बनाने के लिए वुमन को एग्रीव्ड पार्टी नहीं बनाना चाहिए. इट ऑल्सो एक्सप्लेन एज टू व्हाई वुमन शुड नॉट बी इन्वॉल्व इन द प्रोसिक्यूशन इन द केसेस ऑफ एडल्टरी. उन्होंने बोला कि अगर वो प्रोसिक्यूट किया जाएगा so it will destroy the marriage and lot of problem will take place. तो ये एक तरीके से मैरिज को प्रोटेक्ट करने के लिए इन्होंने लगा दिया था. And then came the third Supreme Court judgment. It is called V. Revathy versus Union of India in 1988. Supreme Court held that not including women in the prosecution of adultery cases promoted social good. It is good for the society. It offered couple a chance to make up and keep the sanctity of marriage intact. Supreme Court observed that the adultery law was a shield rather than a sword. कि भाई ये एक तरीके से प्रोटेक्ट करता है rather than एक दूसरे को काटने के लिए यूज नहीं होता है. ठीक है. So this is what, these are the three, you can say, Supreme Court judgments. So what are the present scenario in the world, ठीक है, about this adultery? British introduced Section 497 in India, but England itself decriminalized and it is not treating it as a criminal, you can say, case. In France, wife is punishable with a minimum term of 3 months to maximum 2 years. In Malaysia, Hong Kong, Singapore, adultery is not punishable. In most of the USA, it is not punishable, or both parties are equally punished. There is no gender discrimination. In Philippines, it is a married woman who alone is held accountable, while in Pakistan and Islamic countries, adultery can be punishable with death or severe punishment. So ये अलग अलग देशों में माहौल है. अब भारत में क्या है? तो भाई भारत में सुप्रीम कोर्ट ने जो अभी जजमेंट दिया उसके बारे में अगर हम बात करें तो इट सेज adultery is no longer a crime. That is what Supreme Court ruled out. But Supreme Court said that it is still a civil wrong and therefore it can be a basis of divorce. The judgment of these 5 judges of Supreme Court, which is headed by Chief Justice उस समय पे के दीपक मिश्रा जी, ठीक है, उनके मुताबिक this was a ruling and the law had come under sharp criticism for treating women as a possession of man, and this case came by an Italy-based Indian businessman called Joseph Shine, who is from Kerala, and he filed PIL and therefore this was removed. Discriminatory था इसलिए उसको निकाला गया. Okay, चलिए, great. So this is you can say a special addition from my side for you especially. Make sure that you go through this, keep taking proper notes. This is very important, and make sure that if you like this particular video, share it to a lot of your friends. Okay, and comment on this particular, you can say, video, like this video, and do not forget to join our ProTalentDigital.com. Okay, thank you very much. All the best.